too.
Good morning, everyone, and welcome to this very, very important morning and day in the life of justice delivery, not in Ghana, but for our dear continent. My name is Samson D. Anyenini, and for all of you joining us, you can be assured that by the time this is over, you would have been very well nourished to assist in getting what the Constitution, that I suppose is not only in Ghana's Constitution that you find in Article 125, that says that justice emanates from the people and it shall be administered by the judiciary, which shall be independent and subject only to the Constitution. I suppose we find this in almost all constitutions. But why has it become so important that we still need to do what must be done today? We will answer that at the end. So without ado, ladies and gentlemen, let's have the purpose of our gathering by welcoming the Justice Independent Fund Manager, Chief Operating Officer, Felix Bigger, to tell us the purpose of our gathering here. Okay, let's have the so that when he's done, then you come in. Forgive me.
That's fine. Good morning. My name is Saeed Salahuddin. I'm the fund manager for the Africa Judicial Independence Fund. Distinguished guests, esteemed members of the advisory board of the Africa Judicial Independence Fund, special guests, colleagues, revered ladies and gentlemen, it is my great honor and privilege to welcome you all to the official launch of the Africa Judicial Independence Fund. Today marks a significant milestone in our collective effort to uphold and strengthen judicial independence in Africa. As you may know, judicial independence is not merely an abstract principle, but rather it is the bedrock upon which the rule of law, democracy, human rights, and constitutionalism stand. Without a truly independent judiciary, the administration of justice is compromised, and the very fabric of our societies is threatened. We have gathered here today to embark on a journey. We have gathered here today to embark on a journey of transformation. Our purpose is clear: to forge a robust framework that ensures the judiciary in Africa can operate without undue influence, without interference, and without intimidation. Through the Africa Judicial Independence Fund, we aim to provide resources and related support to institutions and advocates working to strengthen judicial independence around the African continent, to uphold the principles of fairness, firmness, and impartiality in the delivery of justice. I would like to extend a special welcome to our esteemed advisory board members whose expertise, dedication, and diligence will guide us in this noble endeavor. I also want to acknowledge all of you here, our special guests, I can't mention your names, who have traveled from near and far to be with us today. The purpose of our gathering this morning is not just about discussions and presentations. It is about building a network of champions for judicial independence in Africa. It is about fostering partnerships. It is about sharing best practices. And of course, it is about creating a collaborative platform to enable us address the challenges and the threats to judicial independence collectively. I encourage each and every one of you to actively participate in the discussions, share your insights, and engage with your peers. Once again, thank you for being here today. Your commitment and support are truly appreciated. Together, we can make a change. Together, we can ensure that the judiciary in Africa remains a pillar of strength with integrity. Thank you.
Please, a round of applause for Said Salahuddin, the fund manager of the Africa Judicial Independence Fund. And he's a lawyer, he's a chartered accountant. He's currently serving as senior finance manager at Afro Barometer. And he puts it rightly where it ought to be. If we secure the independence of the judiciary, we clearly secure a just society. And this is an important part of that process. Now, let's welcome Felix Bigger, the Chief Operating Officer, to introduce to you the board and our special guest.
Thank you, Samson. Ladies and gentlemen, it is my very honored duty to introduce the advisory board for the Africa Judicial Independence Fund. I must say that I'm so highly honored. You know, when I see the bios here, we are really, really grateful to you all for putting yourselves up for this important task. So I'll introduce the chairman of the board. The Honorable Professor Willie Mutunga was Kenya's Chief Justice and President of the Supreme Court from 2011 to 2016. He served as Secretary General of the Commonwealth Special Envoy to Maldives in the second half of 2016. He was a distinguished scholar in residence at Fordham's Law Leitner Center for International Law and Justice School from October 2016 to May 2017. In October to December 2019, he was one of 2 foreign experts who advised the Constitutional Review Commission of the Gambia on its draft constitution. Since October 2011, Justice Mutunga has been an adjunct professor in public law at Kabarak University School of Law. Justice Mutunga, who studied law at Dar es Salaam University and Osgood Hall Law School at York University in Toronto, Canada, played a pivotal role in the constitution-making process in Kenya and in the 1970s and the early 1990s. He worked on implementing Kenya's progressive 2010 constitution as head of the judiciary and president of the apex courts in the country. In his writings and judgments, he advocated the development of indigenous, robust, patriotic, decolonized, de-imperialized, pro-people, democratic, and progressive jurisprudence that is not insular and does not pay unthinking deference to other jurisdictions, regardless of how prominent they are. During his tenure as Chief Justice, Justice Mutunga sought to lay permanent and indestructible foundations for transformed judiciary. Under the blueprint of the Kenyan Judiciary Transformation Framework, 2012 to 2016, he achieved impressive progress in bringing the justice system closer to the ordinary people. He also worked on the linkages between formal and traditional justice systems as decreed by the Constitution of Kenya. Justice Mutunga is well known for his fight against corruption in the judiciary and in Kenya as a whole. He spearheaded the independent and principled dialogue, consultation, and collaboration between the 3 arms of government: the devolved government and civil and corporate society, the media, the public, etc. Under his watch, the notion of the judiciary as an institution of political actor began to take root. Ladies and gentlemen, please, let's put up claps for our chair of the advisory board, Professor Willie Mutunga. Professor Mutunga is seated at the extreme end of the first row. I go to another luminate, Professor Augustin Loada. Professor Loada is an accomplished individual with diverse backgrounds. He graduated from the institutions in Burkina Faso and France and has taught public law, political science, and other subjects at universities in Burkina Faso since 1995. Furthermore, he has been practicing law since 2016. Professor Loada was a Fulbright scholar at Boston University in the USA and became a member of the American Political Science Association in the year 2000. He served as a founder and the first executive director of the Center for Democratic Governance, a research center in Burkina Faso that focuses on governance and democratization. CDG is Afrobarometer's national partner in Burkina Faso. He also established and headed the Institute of Governance and Development in Burkina Faso, which in partnership with the APSA organized a workshop on religion and politics in comparative perspective in 2013 in Ouagadougou. Since 2016, he has traveled frequently to New Caledonia, a French territory in the Pacific region where he participates in the UN group's electoral experts and later led a group from 2018 to 2023. Professor Loada continues to teach. Ladies and gentlemen, I present to you Professor Augustin Loada. I am pleased to also read the bio of Ayo Obi. Ayo is a member of the advisory board. Ayo is a legal practitioner and partner with the Olasupo Shonibare in the Lagos-based firm of Ogunshola Shonibare LP. I'm sure I'm butchering the pronunciation. She is a trustee of Senegal's Gorée Institute and of the Brussels-based International Crisis Group. In Nigeria, she is on the board of the ZO, the Biazue Memorial Libraries, and is an active member of the Bring Back Our Girls campaign. Obi was president of the Civil Liberties Organization, Nigeria, from 1995 to 2003, and has also been chair of the Transition Monitoring Group, the steering committee of the World Movement for Democracy, and Nigerian Civil Society panel on police reform. She represented Nigeria. She represented Nigerian human rights organizations on the Police Service Commission from 2001 to 2006, and was a trustee of the Clean Foundation from 2001 to 2015. From 2006 to 2009, she headed the elections program of the National Democratic Institute's Nigeria office, and also served on the steering committee of the Nigerian government's Forum State Peer Review Mechanism. She has been a panelist on the Women's Forum in Deauville, France, and Oslo Forum, the Beijing Forum, and the Chino Achebe Colloquium. There's a lot I can read. Ladies and gentlemen, welcome Ayo. I want to also introduce Professor Henry Kwesi Prempeh. Professor Prempeh is not here today unavoidably, but he's agreed to be a member of the advisory board. Professor Kwesi Prempeh is a distinguished legal scholar and a governance expert, and currently serves as CDD's executive director. Prior to their role at CDD, Kwesi Prempeh taught at Setham Hall, the University School of Law in New Jersey, USA, from 2003 to 2015. He achieved tenure as a full professor in 2008. Additionally, he served as a visiting professor at the Gimpa Law School in Ghana from 2010 to 2011, and has been co-teaching Constitution Building in Africa course at the Central European University since 2014. In 2013-2014, Kwesi Prempeh acted as the constitutional law advisor at the UN Special Envoy to Yemen. He was also a Reagan Fassel Democracy Fellow at the National Endowment for Democracy in 2011. He is widely recognized for his expertise in democratization, governance, constitutionalism in Ghana and in Africa. I could read a lot as well. So we welcome in absentia Professor Kwesi Prempeh. Finally, but not the least, Kajal Ramjathan Kiog, and pardon me if I mispronounce your name. Kajal is Director of the Africa Program at the International Commission of Jurists, ICJ. For those of us who are not familiar, ICJ is an international non-government organization founded in 1952 with a mandate of defending human rights and the rule of law worldwide. One of the core pillars of ICJ work is the promotion of independence of judges, and we are really, really happy that Kajal agreed to join us. Kajal is South African. She's a lawyer. She's based in Johannesburg and has worked in the human rights sector for more than 20 years. She was the executive director of the Southern Africa Litigation Center from 2015 to 2020. At the Southern Africa Litigation Center, she led many strategic litigation cases, focusing on various human rights issues and in particular judicial independence, rule of law, international criminal justice, freedoms of expression and association, and so on. Again, I could read a lot. Ladies and gentlemen, let's welcome Kajal. So with that, I'm pleased to hand over to Samson. Thank you.
Thank you very much, Felix Bega. So, it's just a joke. It's an uninspiring and interesting joke. So, perhaps because his name is Bega, and I have not interacted with him until today, this morning when I have interacted with him several times, Bega replaced Salahuddin. How did that happen at the very start to give us the introduction? You are Bega. Thank you very much. Now, ladies and gentlemen, I understand that we all will appreciate that we're starting about an hour late, but understandably, there was a reason for this. So I'm going to be holding, including my lot that is difficult to attempt to hold, to time. And I'll be holding one microphone. If you hear the microphone tap this way, it means you have 5 minutes to round up. If you hear it the second time, it means you must stop. I'm no judge, but on this occasion, I'll be stopping judges when they are advocating. It's the other way around. When I go to court, they stop me. Today, I have the very rare opportunity, not given by any constitution, but Afrobarometer. Ladies and gentlemen, on that note, we would like to begin by having some reflections on the experiences and struggles for judicial independence in Africa. We want to learn lessons from Kenya, a country that many African countries are referring to today and feeling extremely proud about the Gen Z because they are living, literally living out what the preamble of almost every constitution and the first article of almost every constitution preaches. That sovereignty resides in the people. It springs from the people, and it must be exercised in the name and for the welfare of the people. I'd like to acknowledge my lords present here. I have seen a couple of justices from our superior courts here. I've seen from the bar, also the leadership of the bar here duly represented. Welcome to all of you. Ladies and gentlemen, let's now welcome the professor whose bio you heard a while ago. Very intriguing, wanting us to think original and not to think with deference to the jurisprudence of other countries. Professor Willie Motanga. Please, let's welcome him.
Good morning. I have only 25 minutes, so let me start. Let me say that, in Kenya we have the transformative constitution, and the judicial reforms in Kenya have been anchored on that constitution since its promulgation on the 27th August 2010. It's clear that judicial reforms were about transforming the old colonial and a continued post-colonial judiciary to a judiciary that was aligned to the new values that will enable it to be an institution of social transformation. The reforms sought to break judiciary's history of being an appendage of the executive, parliament, bureaucracy, the national and foreign interests that undermine its independence and integrity. The Constitution envisioned a judiciary that would be pro-people and live to the decrees of the Constitution as an institution exercising delegated sovereign power from the Kenyan people. The Constitution also recognized that citizens and organizations would run to this temple of justice when their rights under our progressive Bill of Rights, a major anchor for a promise of democracy, were denied, violated, infringed, or threatened. Similarly, the temple of justice would be the place to seek remedies when the Constitution was contravened or threatened with contravention. The Constitution also addressed the fundamental question of political leadership, the leadership that has the responsibility and the power of our resources. And the issue of leadership and integrity finds its place in Chapter 6 of the Constitution. Kenyans were aware that unless we had a patriotic pro-people leadership that would guard our resources and be committed to breathing life into the values and principles of governance in the Constitution, no social transformation will take place. So the Constitution provided various sites of struggles where the barriers to transformation could be challenged and overcome, granting independence and integrity to all institutions of state was made to cure the virus of imperial presidency and its negative impact on all institutions of governance. Devolution of political power to 47 counties and decreeing an equitable distribution of resources between the national government and the county government aimed at building one indivisible sovereign nation. That was equitable and reflected the face of Kenya, its ethnic, cultural, and religious diversity. Marginalization in whatever form, gender, community, religion, race, sexual orientation was to end as we build a united sovereign nation. Let me pause here and basically say the assessment on the implementation of the Constitution is through a metaphor in Kenya where we say the Constitution was born a beautiful baby, but we handed the baby to child traffickers. And so the struggle for its implementation still continues. So a transformative constitution, there's been a lot of writing on transformative constitutions, particularly by the South Africans, a South African scholar, a former Chief Justice of South Africa, have defined and written on transformative constitution and the constitutionalism of South Africa. Transformative constitutions and their jurisprudence collectively capture the idea of fundamental societal change through the instrumentality of law. Okay, Judge Cameron and Sachs have also, described what a transformative constitution should be, and Sachs says the Constitution opens with the words "we the people," and yes, it can just be a piece of paper. If we the people ignore it, if we trample on it, if we disregard it, it will just be a beautiful piece of paper. But if we the people make principled and effective use of rights of that previous generation that fought to have it included in it, then without shedding anything of its beauty, it will achieve its potential to be an instrument of major transformation and justice in the land. And as I've said, a transformative constitution depends fundamentally on which political leadership will implement it. In the case of Kenya, our current president and other presidents were opposed, to that constitution. So it's if you have a transformative constitution, it remains still abstract unless you have a leadership that is committed to breathing life into that particular constitution. So the issue of political will, is important, and we've realized ourselves in Kenya that the constitution itself, what we've done in Kenya, is basically look at these sites of struggle, and there are many, on issues of land, issues of, Bill of Rights, issues of gender justice, issues of the institutions themselves, finance, national debts, everything is there. So there is a robust public interest litigation that engages in crafting, political demands from, that constitution. Now, in the case of Kenya, if it's the issue of jurisprudence, the Apex Court has said very clearly that constitution is a transformative charter. So the Article 1 of the Constitution, okay, is the one that states very clearly that sovereign power belongs to the people, of Kenya. And the sovereign power of the Kenyan people becomes supreme and central in the implementation of the Constitution. The struggle for the sovereign power of Kenyan people against representative power is a site or venue of struggle against the leadership, executive, and legislative and judicial authorities that derive their power from the Constitution itself. And the Article 10 of the Constitution gives the values and the principles of governance, and one of the critical value is one of public participation. And this jurisprudence of the participation of the people in development has called for robust involvement on the basis that people think and they know of their material needs. And the courts have defined what public participation means. And this has been very useful in the development of our jurisprudence, especially as we unearth the sweeter deals of our corrupt elite that are being subjected to this public participation by the people and through public interest litigation. A good example was the standard gauge railway that the Chinese constructed from Mombasa, to Nairobi, and the railway ended up in President Uhuru Kenyatta's farm. The documents were not given. And when they were given, they were not the real documents, and the struggle to have them still continues. But in Kenya, we like laughing at our presidents. We always say that investment agreement was written in Mandarin, and our president still signed it, although he didn't speak or write Mandarin. Now, at this issue of Article 1 now, I just wanted to talk very briefly about the Gen Z revolution, the millennials, and what has happened in Kenya. It's actually, as one of the former speakers said, it's people just using that as a size of struggle and basically saying, look, we have delegated sovereign power to you. And they are talking about parliament and executive. And we are withdrawing that power, from you. And so the slogans have been Occupy Parliament, Occupy State House, Occupy IMF and World Bank, which is a great extension in the case of Kenya of connecting the compradors to their foreign masters. And of course, it's been this particular movement has been met with a lot of violence, etc. But it continues. It's likened to the Mo. Those of you read that speech that Karl Marx made in toasting the Chartist movement. He called revolution, the more that just digs and then erupts. And I think what's happening in Kenya is that, the movement is everywhere. These are the kids who, as Professor Karuti reminded me last night, who used to burn schools. And they are everywhere, and it's just the anger, but everything is about their material interests, freedom of education, the healthcare, and a lot of this started also during COVID. The slogan "Ruto must go" is still one of their demands. But what is being discussed by a lot of Kenyans now, the usual suspects, the opposition, have of course called for dialogue. But the discussion at the moment is to make sure there is no political vacuum after, Ruto goes, or after he stays. So in terms of the judiciary, because we are talking about integrity and independence, so it's important to know that during the colonial period, the judiciary was an appendage of colonial government. Indeed, it was a department of Office of the Attorney General. Now, history records that the judiciary did not stand up against the gross injustices of colonial domination, oppression, apartheid, and exploitation. That period has been described as the rule by law, where the rule of law was absent. The judicial recruitment was done by the colonial government, including the personnel in the native courts. And this definitely was the same feature of governance in other colonies. Let's see. Yeah, you find, if you read Makosla Neyashinga, you find this issue that they discuss. And they write satirically of plagiarizing the late 19th century poet Hilary Belloc. Whatever happens, we've got the common law and they have not. And in the case of Kenya, there was a trial of Jomo Kenyatta, the first president of Kenya, where this is demonstrated, where the rule by law is gleaned. The post-colonial period now, from 1963, saw the continuation of colonial judiciary. The British judges were in charge until the late 1980s, except for 1968 to 71, when the Chief Justice was an indigenous Kenyan, with appointments being made by the President, the Judicial Service Commission. That rubber stamped the President's decrees during that period. But the Constitution deals with this issue of appointment because it's very, very, very important. Vacancies are advertised, and the processing of the application by the independent representative JAC, and you shortlist the candidates on criteria provided by the Constitution. Interviews that are televised and open to public participation. Members of the public can basically come up and say that a particular candidate has integrity, the issues, and those who are nominated the names are submitted to the President for swearing in, except for the Chief Justice and Deputy Chief Justice, who the President has to send their names to Parliament for, for vetting. And it's a Judicial Service Commission that also recruits judicial officers, magistrates, and staff. There is no public participation in this case, but people can participate through public litigation if they disagree with the appointment. And the JSC itself is because I've said the old JSC was just enslaved by the president. The current one is more representative, and the Chief Justice is the chair of the Judicial Service Commission. The Supreme Court and the Court of Appeal elect judges to the Judicial Service Commission. The High Court and the magistrates have a woman and a man elected by an association of judges and magistrates. The Attorney General sits there, 2 advocates, 1 woman and a man, each elected by members of the LSK, the Law Society of Kenya. And then there are 2 people who are nominated, 1 woman, 1 man, to represent the public. And they also are vetted by Parliament. And then the Chief Registrar of the Judiciary is secretary. There's still a debate as to whether the JSC in Kenya is independent and impartial, and who should sit in it. But that's a struggle in the implementation of the Constitution. There's been an interesting development in Kenya where presidents refuse to swear in judges, and they invariably say that they are not rubber stamped, so they have to participate, although they are represented in the Judicial Service Commission. But the courts have actually ruled that the president is a rubber stamp. Once the JSC nominates these judges, the president has, to swear them in. And recently there was a case where the president refused, and the judges said that the Chief Justice herself, should, swear them in. But the Chief Justice appealed against that decision, and the case hasn't been heard. But these swearing in are just, they are not anchored to any particular legislation. They're just conventions, and we're debating on how this issue of swearing in can be concluded. But at the moment now, the Chief Justice swears in the President and the Deputy President, and the Chief Justice is also sworn in by the President. So that's about the recruitment, which is important. Then we can also talk about the new judiciary in the sense that those who are recruited under the Constitution are joined by others who were employed before the Constitution was promulgated, and they were subjected to vetting to find out if they were suitable to serve in the new judiciary. And the vetting involved people like Abby Sachs and others. And, quite a number of the judges and the judicial officers were asked to leave. Now, independence of the judiciary is a fundamental pillar of judicial, integrity. And the discussion has been around, what this entails, and the traditional definition of this principle tends to focus on what Lee and Campo define as the principle focuses on the creation of an environment in which the judiciary can perform its judicial functions as one of the three branches of government without being subjected to any form of duress, pressure, or influence from any person or other institutions. But modern transformative constitutions have gone further, and they like in our constitution, or in our practice, we know very clearly that you can't just stop with the executive, parliament, international and national corporate sector. The civil society itself can be a force that undermines the independence of the judiciary. We focused on families as well. We've had many cases where judges were incorruptible, removed, or there are petitions against them because their wives took kickbacks without the judge knowing, and their sons and daughters, friends, family, ethnic community. My challenge as Chief Justice about independence came from my community. A lot of people, self-appointed busybodies who came to court and told me, why are you building courts in far-flung areas of Kenya? And I realized that in a country where politics is organized around ethnicity and other divisions, the moment you get into a position like your community thinks they have captured one arm of government, and they will come to you and basically, tell you how you should run the institution. And in my case, when I got tired with, their advice, I told them, to get out. And I remember what one of the pastors told me. He told me, when you get into trouble, don't come to us. To which I replied, well, I'll go to those communities who I'm giving courts. So there are those issues of religion, there are quite a number of, issues. And I've mentioned civil society because in 2013, we decided a presidential petition, and some of the civil society leaders were very upset. They thought I should have helped their candidate. And it was a very, very shocking experience where people who are in human rights, social justice movements, who are aligned to a particular faction of politicians would expect a chief justice to rule in the favor of a particular person. And of course, when I asked them, we are 6 of us, what did you want me to do? They didn't tell me, but I guess they wanted me to have a big stick and, force the other 5 justices to cave into that particular decision. So those insidious forces against the independence of judiciary are rarely discussed, and they ought to be discussed. The Kenya Constitution has definite chapters on financial. Okay, sorry. Okay, I've got my marching orders. Let me. I've exceeded my time by 3 minutes. Let me see how I finish this. I can always share this paper. So I've talked about the judiciary could be its worst enemy. There are cases where the Chief Justice subverts that independence. I've seen benches that are set up to hear cases, and the presiding judge takes the role of basically suppressing that independence. I know there's an issue of politics in the judiciary. My view has always been that transformative constitutions actually have their own judicial politics under those constitutions. And Professor Oloko Nyango of Uganda and Professor Ubetra Baksi, who used to teach in Warwick, they all have written extensively about, that judges and courts do politics. The last thing I wanted to mention about independence of the judiciary is the African justice systems, where we've been trying very hard to comply with the Constitution and have these African judicial systems in place, because 95% of Kenyans don't come to the formal courts. And that discussion is ongoing. But it's a very important project, because we believe that that's how the judiciary will get its following among the people. And we are at the stage where we are discussing how informal and formal can be integrated. Okay, so in conclusion, in 1 minute, the concept note on the African Justice Judicial Independence Fund reflects a lot of the ideas I have. In the case of the Z revolution that we've talked about, I just need to add that the fund will have to address this issue of movements and see how they can, facilitate them. And the JC, I think my president was hard to look for that General Z who is bothering him. Reminded me of Idi Amin looking for foreign exchange in central bank, who was always absent. But this mass action by JSC has actually led, at least for lawyers, a discussion of whether you can have a change of regime under constitution. They're looking at Articles 1, 2, and 3. So, as judges, we might not have to go back to Kelson, as the Ugandans and the Zimbabweans did when there were coup d'etats there. We might just find that there can be regime changes anchored on the Constitution itself. And I thank you very much.
Thank you very much indeed. Please, a round of applause once again for Justice William Matanga. So, depending on where you are coming from, the story about how the Kenyan Superior Court or the justice system operates can be inspirational and can be one that the manner in which Prof speaks about the assertion of their independence is just admirable. That at a point, the CJ has to contemplate being the one to swear in justices, and the CJ then decides to take up an appeal against that decision of the court, and the executive says, we will not swear in because you are reducing us to mere ceremonial function of swearing in without actively participating in who becomes a justice of the Superior Court. For some people, that is a story of boldness, of resilience, of independence, of a judiciary that you can see. So, I'm sure we are getting there bit by bit. And I had to ponder over a number of questions as the Africa Judiciary Independent Fund launch came up. In almost every constitution, once again, I think, I'm very familiar with the Ghanaian one. It says you are not qualified to be a justice of our courts, whatever the rank, unless you're a person of high moral character. And it doesn't end it there. Proving integrity. So why are we here? Should there be a discussion in the first place? And these qualifications and even the independence is not only secured by constitutional provisions, but those constitutional provisions in Ghana are secured in our chapter 25, meaning they are entrenched. You can't, by your whim, change them. If you need to change those provisions, particularly articles 125, 127, where the independence is properly stated and guaranteed, you need to do it through a referendum. All those qualified to vote, you need as many as 40% coming out to vote. And out of that 40, you need a whopping 75% to endorse the change you need to make. This is the independence they enjoy. Almost untouchable. And yet, there are questions about their independence, both decisional and institutional. Ladies and gentlemen, I would like at this point to welcome our next speaker. We will be asking Prof a number of questions. You will have the opportunity to ask him also when we begin with the panel session. He will be taking the questions together with our next guests. And Our next guest is a senior I'm proud in, and I appeared before her in her court, and many will say that she was forthright in the manner she dispensed justice. She's a distinguished legal practitioner, professional, a full-time law lecturer at the University of Professional Studies, Accra, UPSA. She served as a district court judge, state attorney, and private legal practitioner here in Ghana. She holds an LLB from the Kwame Nkrumah University of Science and Technology Law Faculty. She was called to the bar in 2009 and earned an LLM from George Washington University, and she's currently pursuing a PhD in law at her alma mater. Ladies and gentlemen, please help me welcome Mavis Kweno, who is taking us through Ekuya Inyama Kwenu, who is taking us through a landscape of a scan that they have done by way of a research, after which we'll have the panel discussion. Lady, I still have a difficulty calling her without prefixing it with my lady.
Thank you very much, my learned brother. Good morning, everyone. Good morning. Distinguished ladies and gentlemen, distinguished members of Africa Judicial Independence Fund Advisory Board, Open Society Foundation, the CEO of Afrobarometer, Dr. Joseph Asunka, Mr. Felix Biga, Lawyer Said Salahuddin, Madam Linda Theresa Abe, and many distinguished others. Together with me, came out with the landscape scan, the research on the landscape scan of judicial independence in Africa. And this morning, indeed, I am so happy and honored to stand before all of you to present to you a comprehensive review of the collective research work that we did together. Indeed, I'd like to appreciate the various comments received from the members of the AGIF Advisory Board that shaped the final edition of this research work. Kindly join me in applauding their efforts. The comprehensive research that was conducted on judicial independence in Africa spanned 11 countries: Mali, Nigeria, Angola, DRC, Democratic Republic of Congo, Ethiopia, Uganda, Zimbabwe, Senegal, South Africa, and our very own country, Ghana. Listening to the earlier speakers, they touched on some of the relevant things that has to do with judicial independence. Indeed, for every democratic state, it is expected that you will see the semblance of rule of law, respect for human rights, through the work of the judiciary. We cannot overemphasize the role played by our various judiciaries across the continent of Africa. They are the beacon of hope to many when it comes to violation of rights, constitutional interpretation, and even the settlement of electoral disputes. They play a very important role. And this very topic is of utmost relevance and important to our work, the Africa Judicial Independence Fund, to ensure that this very important organ of government, the judiciary, at all times is actually independent in the true sense of it. There are so many beautiful legislations out there at the international level, at the regional level in Africa, and also at the national level in our various constitutions, where you come across very important provisions that speaks to the issues of judicial independence, which has got everything to do with the institutional independence of the institution, as well as their decisional institutions, where we could see the determination of disputes based strictly to the law and the fact in issue without any form of external influences. Now, kindly permit me to take you through many of the challenges that we came across in this research. As part of our objectives, our aim was to assess, in fact, understand and assess the independence of our various judiciaries across the African continent. Identify key actors, policymakers that promote judicial independence across the continent, identify some of the challenges, and come out with actionable recommendations that could help policy change and make the independence of the judiciary more practicable. Because when you look at the things we see on a daily basis, in reality, you observe and agree that indeed there's a disconnect between the theoretical understanding of what we talk about when we talk about judicial independence and then the practice of state parties. Of relevant importance are some of the international laws, human rights instruments, which explicitly deals with judicial independence. You take the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, talk about the African Charter on Human and People's Rights, the UN Principles of the Independence of the Judiciary, and many others. They all touch on the need for the independence of the judiciary as an institution and in the performance of their various functions. Now, with respect to the overview analysis of the state of judicial independence in Africa, the challenges of the judiciaries, not only in Ghana, but across the whole continent of Africa, includes issues of non-compliance of the orders of the court, violations of the orders of the court. Non-compliance and violations, I think, should stand together. Interference of all forms, both within and outside of the work of the judiciary. When you take interference from the external, it manifests mostly with the undue influence and the much pressure exerted on the judiciary by, in particular, the executive arm of government. One other major challenge of the members of the bench has to do with the constant threats against their very person And when we take conflict-torn states in particular, the issue of the independence of the judiciary is absent. There are situations where judges live in an environment of fear. They lose their balance because there is no practical support to make it happen when we talk about judicial independence. Then again, part of the challenges has to do with socio-economic matters. It is a problem which cuts across the entire African continent. I'd like to speak to some of these matters in some detail. When we talk about executive interference, it takes or manifests itself in different forms. Indeed, judicial independence is one of the key principles of judicial ethics, together with integrity. But this idea has some foundation in the concept of separation of powers, where we have each of the various arms of government performing their distinctive functions, be it members of the executive, the legislature, and the judiciary, and at the same time, constituting the system of checks and balances. So on the issue of interference, when you take the appointment of the members of the bench, it is mostly not left in the hands of only one organ. There's always that collaboration between almost all the organs of government, with much power vested in the executive arm of government to determine at the end of the day who sits on the bench. And that is where we see the issue of executive interference playing out to the extent that members of the public tend to believe that the courts have been packed with persons who are more sympathetic to the cause of the government in power, whether perceived or real. We all live in a society, and you are the best judges. Then again, another issue with the appointment process has to do with whether the various appointees even merit the said appointment, whether these appointments are merit-based or is being made based on the pleasures of those in power. So executive interference does not only affect the independence existence of our judiciary, but also has everything to do with the low levels of confidence we're experiencing as members of the public in the work of the justices, where most members of the public hold the belief or perception that for those who wield power, you can never win a fight against them because they have their favorites working for them in the other organ of state, the judiciary, despite the fact that when you take, for instance, in fact, the constitutions of Kenya, of Ghana, Uganda, any of the countries that I made reference to, you come across provisions guaranteeing the independent functioning of the judiciary. But in practice, there are so many cases, reported cases, where the reality was absent, weakening independence of judicial officers, mostly emanating from the heads of judiciary, heads of the various bench, affecting the work of their colleague, members of the bench, or even their subordinate, all working against the independence of the judiciary. Societal attitudes and perceptions is also a major challenge. When we talk about the issue of corruption, societal attitudes and perceptions, sometimes the acts of engaging in corruption tend to conflict with some cultural practices, which all works against the independence of the judiciary, particularly when it comes to decisional independence of judges, who sometimes, unsolicited, are approached with fine gift, I would say, unsolicited. But you'd agree that ordinarily such gifts will not be thrown at the members of the bench, but for the positions they occupy and for a future arrangement in favor of the donor of the said gift. These are all matters of interferences from various factors, here in particular societal attitudes and perceptions and corruption as well, which hinder on the independence of the judiciary across the continent of Africa. And based on our findings, we propose the following recommendations to strengthen judicial independence in Africa. There is a need for some form of institutional reforms to implement a transparent and merit-based appointment process like those found in South Africa. When we talk about their tenure of office as judges, there's a need for legislations that will guarantee the tenure, the safety of the security of tenure of judges for both the lower bench as well as the Superior Court of Judicature. Very importantly, the issue of funding has always been a major challenge for most judiciaries across the continent of Africa. Budgetary allocations often comes very low, always inadequate to satisfy all the major needs of the judiciary, resulting in a work environment, particularly for members of the lower bench, which are somewhat deplorable. So there's a need to enhance the budgetary autonomy of the judiciary. Presently, in practice, there is nothing like that. Most of the judiciaries in Africa rely on the other organs of state, particularly the executive, for that funding support. Another recommendation we propose for us to see the change we need to see has to do with the empowerment of civic groups or civil society. They play a major role in putting almost all the members of the various arms of government in check. There's a need for collaboration with civil society organizations to advocate for judicial reforms and also monitor government adherence to some of these international standards and ethics. These international standards and ethics providing for Judicial independence, integrity, and all the others were not put in there for the fun of it. These were placed in there as obligatory, particularly when you look at the African Charter for Human and People's Rights. It makes it obligatory for state parties to uphold the principles embedded in the entire charter, but in particular with respect to judicial independence, where state parties are obligated to ensure that it's not only resting in their books, but is also practicalized and even domesticated in their national constitutions. Civil society's active engagement in holding government accountable is very crucial in our collective efforts to make judicial independence much more of a reality than we presently are all experiencing. For which the moderator was asking, why are we here? There's much more work to be done. There's also a need for regional collaboration. Various judicial institutions found in each of the African states cannot do it alone. There's a need for some form of collaboration across jurisdictions to promote regional cooperation for the exchange of ideas, best practices, and resources. Even when it comes to the enforcement of court rulings and judgments across boundaries, that would make more easier. Regional cooperation will lead to some collective measures taken by all members of these judiciaries across the various jurisdictions to strengthen their independence through regional protocols. For instance, we have the ECOWAS Additional Protocol on Democracy and Good Governance. These are examples of what regional collaborations can do. There are so many beautiful laws already in place. They need strengthening. We could have a multiplicity of laws, but without a strong system for implementing these laws, these laws will not produce the desired results we all need. Judicial integrity needs to be promoted. And as my learned brother rightly mentioned, there are so many requirements if we want to sit on the bench, apart from having the needed academic qualifications. That individual must possess or be somebody who could describe as of high moral character and proven integrity. We need more persons. Such were the persons who have been nominated to sit on the bench. But for reasons best known to some of them, when they are placed on the bench, their actions are far from these two crucial values expected of the members of the bench who are entrusted to be persons of real integrity to dispense justice to all equally. Judicial security is very, very important given the constitutional mandate given to each of our judiciaries across the African continent. The security of that is very crucial. In the settlement of dispute as one of the core mandates of the judiciary, most of the times after every election, the judiciary is confronted with an election dispute where they influence the outcome of political decisions. You can imagine if the decision of the judiciary does not align with the interest of the appointer, certainly it would result in what? Attacks, threats, and the safety of these judges. And as we speak now, such is the case in many of our African countries. Last night, as I was watching the news, I was amazed to find out that presently, even in Guinea, the courts are on strike because of arbitrary arrest, arbitrary detentions of judicial officers, legal officers to unknown detention camps. This discussion is very relevant, and it would take our collective efforts to make it happen. Today is not a day of presentation of papers, but it's a day of true reflection on where we started from and where we are, and what we can do to change the status quo. So before I take my seat, I would humbly plead with all in this room never to let this discussion end here, but to be champions, as our brother Saeed Salahuddin mentioned. We all in this room must pledge to be champions of this very vital ingredient we need for all of us. Without an independent judiciary, you and I will not have that confidence to approach the courts without disputes. And if that happens, where would you go? I have nothing more useful to add, but to thank you for your kind attention and participation in this discussion.
Thank you very much. Please, another round of applause for our distinguished speaker. Now you get the opportunity to participate. So I'll urge you to write down your question. It helps you to ask it in a rather straightforward and crisp manner. Write down your question. We're going to have Prof and my lady join us here for a quick discussion. On the back of their presentations, we have a number of questions for them to try to explain some of the points they have made. A while ago, I saw Professor Jimabwedi here. Professor Jimabwedi has been a household name in Ghana in our governance. He is a member of the governance board of the CDD, Center for Democratic Development, Ghana. Very blunt. Doesn't matter whose ox is God. As far as the matters have to be said, he will say them. I acknowledge the presence of Justices Richard Apietu and Frank Abwadji Jackson. Thank you very much for being here. I also acknowledge the presence of Dr. Kojo Pumpuni Asante, also of the CDD, Professor P. Lewis, and Xavier Kuji, my senior, the PRO of the Ghana Bar Association. And a while ago, I attempted to whisper to him how they have, as a body, tried to redeem the profession by stating an opposition to the proposal to expand the Supreme Court bench from 15 to 20. They insist that if it has to be done, it has to be done properly through a constitutional process and not by the CJ putting down the names of 5 judges, presenting them to the president for consideration for appointment. Ladies and gentlemen, please let's have our speakers back up here so that we begin the session of interrogating some of the issues that they have raised. Please put your hands together once again for them. Professor Mutunga.
Okay. All right.
So I will set the ball rolling. But as I mentioned earlier, please get your questions ready because they are more important in this session. So you gave us a certain general overview of the problems as your research appears to have identified. And thankfully, we have someone like you who has been in there, in the judiciary. Not to put you on the spot. These influences, particularly from members of society, unsolicited, as you suggested, how exactly are they manifested? How difficult is it for a judge who has sworn an oath not to be influenced to overcome them?
Thank you very much for this question. Yes, the issue of external influences takes the form of receiving gifts. Receiving gifts. And I remember before I was appointed as a magistrate, as part of the interview questions that was posed, was whether I would ever accept any kind of gift upon assumption of duty. My answer was no, without an exception. But these are matters that are real. I have been a magistrate before, served in different courts. I experienced it. They are real. And as part of our cultural practices as Ghanaians, I remember one of the old district courts that was cited in a suburb called Jamestown. The court was located right in the palace. The palace. And as part of our cultural practices, when there's a new judicial officer posted to that court, out of courtesy, it's a traditional courtesy, the chief and his delegation will come and welcome you. And as they come in, they don't come with bare hands. They come well prepared, not with cash, but with a welcome gift, as traditionally is expected of the chief and his delegation when they are welcoming their guests. Such was one practical example I could share. And as to whether I received the gift that followed, your guess, I never took it. I appreciated them for their bold initiative of welcoming me. I remember telling the said chief, he's late now, that I was his daughter. He was really advanced in age. I was his daughter, and I was there to do my work for all Ghanaians. Not only in that court, in another court at the Amasaman District Court, yes, I experienced the visit of such delegations again. From persons of influence occupying some public institutions. As to why they came as a delegation, I do not know. But most of the time, certainly they have, their visit is not ordinary. There are always hidden agenda. But it was always my practice never to fall, never to fall. Lastly, on the issue of receiving gift, upon my return from from studying LLM abroad, I reported back to work and I resumed working in my old court. Within a matter of a week, after every court sitting, my attention will be drawn to someone wanting to see me privately in chambers. I was amazed because prior to my exit for further studies abroad, that wasn't the case. That happened once in a while. But within a span of that time, the request to see me was just suspicious, not knowing indeed these were what? Entrapments. I thank God I escaped them all. So for judicial officers who are presently on the bench, they should be on guard.
Right. So
they should be on guard.
What you speak about
Yes.
has to do with personal integrity issues and avoiding situations that will compromise your decisional independence. You find in the research that executive interference is a significant threat to judicial independence. Briefly, how is that manifested? And what would you say has been its tangible impact on judicial independence on the continent? Or at least for the 11 countries that you looked at?
Yes, thank you again for this question. On the issue of executive interference, I was very delighted listening to our Honorable Professor Justice Willie from Kenya. In his narration, he mentioned when he was advised that when you get into trouble from those who appointed you, don't come to me, the priest. And then he responded, he will go to where the places where he cited the courts for help. Most of the times, and in particular for members of the superior bench, there is that direct contact with the executive arm of government in the appointment process. But for the lower bench, you just receive your letter inviting you for an interview, and then, in fact, the procedures are different. So the interferences from the executive in the work of the judiciary normally happens when they have a dispute of all forms. It could be land, it could be in any subject matter, and they expect a certain outcome. But where it doesn't, but where at the end of the day, the final ruling or judgment goes contrary to the expectation, it leads to what? Dissatisfaction, and it doesn't end there. Some judicial officers suffer without even knowing. From demotions to transfers, and finally, some are even induced to leave, exit. Okay. Yes.
Right. And there's something that sticks out for me as I listen to my lady speak. I don't know about you. I can tell the hesitation even within this forum, where there's expectation of a lot more openness and frankness. I'll go to Professor Motenga. During your tenure, and we're talking about judicial independence in practice, and once again, not intending to put you on the spot. During your tenure, how would you say that these acts of executive influence may have manifested in one way or the other in Kenya. And how did you have to assert your independence?
No, I think, sorry. Actually, when you appointed Chief Justice as I was, that manifestation starts from the day one when you are being sworn in. Because there is a ceremony, where you driven to the State House. And when the town is closed down, you sit in your Benz and there are cars, and when you get to State House, you find the entire elite is there to welcome you into that club. So it's the seduction of powers starts the moment you sworn in, and the only way that I dealt with that issue, because it's always there, is to de-individualize, my office. In the judiciary, there are actually associations. In Kenya, you have the Kenya Women Judges Association, you have the Kenya Magistrates and Judges Association, you have the Kenyan Staff Association. You even have another institution called JLAC, which is the Judicial JLAC Leadership Advisory Council, and then you have the JSC, and there's something else called the National Council for the Administration of Justice. So there are leaders in those particular groups, okay? And so when you have discussions with president or politicians, you must have witnesses, because if it's one-on-one, they are very good at saying what you talked about. But if you create a leadership of the institution, and you don't have to take individual decisions, okay? And when you have press conferences, those people are visible. That helps. But those perceptions are there. The president, the ministers, and everybody else. I mean, we're talking about an institution that has always been enslaved by these forces, and they haven't let go. So it's actually that struggle. And if you have, that collective leadership, within the judiciary, you can resist, because the issue is basically, to resist that influence. And I have those discussions openly in the Judicial Training Institute, where everybody is there so that they can understand the challenges that they have. And if you are a judge in some far-flung area, you can imagine the pressure, because they are the ones who give you security, they are the ones who make sure you do your work. So I don't know how the colleagues who are in those particular places, deal, with that situation. But that's how I dealt with it.
Judges generally have a fixed tenure,
Yes.
so there's a security of tenure.
Yes.
There are remunerations set in constitutions that say it cannot be varied to their
That's right.
disadvantage.
No, it can't be.
So, what is it that makes a judge want to behold to the executive and to do the executive's bidding? When the executive, for example, loses the power after appointment to sort of remove them.
Uh, I don't know. I don't know what judges see in. There are various issues. The judiciary in Kenya, for example, has its own divisions. I was talked about the judiciary being its own enemy. There are divisions on ethnicity. There are divisions on religion. Very, very serious ones. And then, of course, of course, gender, as well, serious issues of, sexual harassment and so forth. I think the problem starts when the politicians or the president has some info, that, and they can get it from their intelligence, and then they use that to whitemail you when that happens. So they have privy, to, a lot of information. And what I discovered in Kenya once was that somebody from the Anti-Corruption Commission came and gave me a list of judicial officers and judges who are corrupt. And I looked at it and I realized all my great judges and the judicial officers were in that list. So the idea is to push those who are women and men of integrity to join the others, okay, through all manner of tricks.
You mentioned civil society having
Yeah.
a significant role to play.
Yeah.
How exactly can they play a role in protecting the independence of the judiciary?
I think, the civil society, of course, there's a religious sector of it, there's a secular sector of it, there are intellectuals, it's a broad, group. But in the case of Kenya, it's a human rights and social justice civil society that, was close to me because I was in the human rights movement, and I worked as a grant maker, so I knew a lot of leaders, in it, and so that was that's the the sector of civil society I was talking about. And of course there are also the pastors coming in. The example I gave of pastors for my my own community and so forth. So I didn't get any call from the president or during my tenure. President Kibaki wouldn't do anything like that. And what is called the red phone in my office never rang. But when Uhuru came in and and Ruto came in, that's when we had all these issues of people not being sworn in, and I discovered that that office of the Chief Justice is a political office, and you have to have a message to give to the president and others. Okay, and whenever I talk to the president, I used to tell them, if you capture the judiciary, when you get out, your enemies will come after you, and what will you do? And I was very happy that happened to Kenyatta, because I used to lecture him on that issue. And his goats, the goats were taken, his trees were cut, his kids had problems of withdrawal of armed licenses and so forth, and they went to the, to the judiciary. So I called him, he didn't pick, but sent him a text. I said, this discussion is, we had this discussion before. And so presidents don't want lectures on the Constitution. if you are going to talk to them, talk to them about politics and how certain decisions will affect their positions.
Right.
And they sit up and listen. But if you say the Constitution provides this and the other, it's a waste of time.
All right.
And that's Kenya. I don't know about other places.
Okay. Clearly good examples that can be picked from Kenya on how to leverage civil society, how to court them, and to use them as an effective measure in protecting the independence of the judiciary. So I'm asking this next question, and I'm coming to you, so get ready with your questions for our speakers. You spoke about socioeconomic factors being a major, factor in that affects judicial independence. How do these factors specifically impact the judiciary's effectiveness and integrity? And more importantly, what measures can be implemented to mitigate the impact?
Yes. Thank you for the question. On socio-economic factors, it's quite complicated. Most of the time, it has everything to do with having in place a very suitable working environment for members of the bench as well as the court staff. Oftentimes, when you visit the various courts, and in particular the lower bench, it is pathetic. For instance, in Ghana, there's been great improvement with most of the lower courts in the city of Accra. It is the environment, the work environment has been improved greatly. But that cannot be said of other places where you have, in particular, the lower bench. It is pathetic. In terms of infrastructure, the working environment itself, basic stuff like furniture and all that becomes an issue. Then again, low salary levels expose members of the bench to fall victims to all manner of corrupt practices and unethical conduct, which all works against judicial independence. And so,
how do we overcome these?
Yes. So, first of all, there's a need to promote the strict adherence to judicial ethics and standards for all members of the bench, irrespective of the work environment you find yourself. It's very important. Then there is also a need for independent monitoring institutions that will have that responsibility of monitoring the performance of the courts, of the members of the bench, in the light of some of these principles that we're looking at. Where they fall short, corrective measures need to be taken immediately before it adds to the low levels of confidence we have in their work. Then again, there's a need for adequate budgetary support allocated for the sole use of the judiciary at all times. Where funding support is so low, and it happens that the judiciary is always constrained in the needed resources to operate effectively, certainly the rule of law, the protection of our rights will be undermined, and their work will be heavily compromised as well.
Thank you. Please, if you have a question, just put up your hand. There's a microphone that is being brought to you wherever you are. I see a hand, Dr. Kujo Pumpuni Asante. Yes.
Morning, and thank you to the panelists for all your insights. I have two questions. I think one flows from Justice Mavis's just reflection on how you deal with gifts and some of the realities of an African judge. I'm just wondering whether in your research you came across any kinds of rules, that guidelines to judges on how to dispose of gifts, how to deal with all these nuances of an African judge, dealing with tradition and all of that. Because I think that is the reality for most judges. I have seen judges, some of the things that are brought to their homes, and I think that there will be training and guidelines and rules that are adapted to deal with that. So maybe just to touch on whether you found that in your research. And the second question is really about perceptions of judicial bias. There, I think both from you and the Honorable Chief Justice, there's obviously a clear difference between what happens at the lower courts in terms of interference and what happens at the superior courts. I remember some years back we did work on legal pluralism, where we spent almost 6 months with some kind of anthropological study, just watching the courts. And there was a situation where somebody had killed somebody in the village or in the community, and the judge and the police and other opinion leaders were going out to go and look for a manhunt to look for the culprit, who was later brought to court, charged and booked and brought before this judge, who was part of the manhunt. So in the rural, there are so many kinds of interferences or culture around it. So I'm wondering, when we are trying to find solutions to deal with the issues of perceptions of bias, should we have different approaches to the high-profile Supreme Court discussions, Supreme Court cases involving, some party or whatever, and what happens on a day-to-day basis with, litigants and so on,
Okay.
which is a little bit different. What strategies should we be looking at those two different things that happen?
Thank you. There's a hand here, right in front here. Yes.
Thank you very much for the opportunity. Yeah, my question touches on this whole concept and issue of the moral character of the judiciary, and all the issues that members of the judiciary are grappling with have already been beautifully expressed in the recommendation. But I just sort of wonder, in your research, whether you also touched on the disciplinary process for members of the judiciary in terms of independence. So on the one hand, there's the pipeline issue when you come in and you swear the oath of office and you're supposed to behave in a particular manner, and you have all the environmental drivers and challenges that you have to grapple with. But then you have so many on the African continent, members of the judiciary who are corrupt. And it's evident in their lifestyle that, they are not living, based on, their income. So what mechanism, what process is there to ensure that when, situations like that are found, or you have a case where a member of the bench is not living up to the values, that there's a clear process to ensure the exit, of such.
Thank you. Please, allow us, let's pause here. Let's take some responses. And I'm hoping that the responses can be quick. And when you have your questioning, also do it very briefly for me because press for time to help you go for lunch. Right. Even though the initial questions were directed at you, my lady, I think your lordship can start on the question of whether or not there are codes to deal with the issues of gifts so that the judges know how to deal with gifts when they receive them. What's your experience?
Yeah, I think in the case of Kenya, it's in the code of conduct. There are cases where you've been sorting, communities if you don't, accept the gifts. So you're supposed to accept, declare them, and I think there is even a kind of a limit. But that decision was taken to basically make sure that, judges don't annoy, people, because some are traditional values where we are being given, gifts, and you can actually hand them over to the, to the courts, if it's a monkey skin or, a beautiful walking stick, it can go to the judicial museum because it's one. But it's a very difficult situation, particularly when you are talking about African justice systems, and those are some of the values that
He spoke with an emphasis on the lower courts.
yes,
A judge in the lower court is looking to promotion.
yeah,
So very easy to influence, particularly at the executive level, right?
yes,
So they will do the bidding of the executive, so they get promoted.
yeah. But if you have a situation where the recruitment procedures, as I laid them down, is robust, they will just get caught as go for the, for the promotion.
Okay.
And we also have in Kenya the declaration of wealth. Every 2 years you have to do it.
Asset declaration.
Yeah, you declare your wealth or your poverty every 2 years, and it's very easy then to track, the lifestyles that my sister was mentioning, the lifestyles of judges. The other thing is, in most, in the case of Kenya, when judges get out, they get permission from the Chief Justice, and they explain why they want to go out, and you give permission. There is a lot of evidence there showing that lifestyle, because if a judge is asking to attend a graduation or a wedding in Berlin and then Toronto and then wherever, and if you have kids all over the place studying, that's the lifestyle you are talking about, and it can be tracked, and they can be removed on that
All right.
basis.
Okay.
Yeah.
What do you have to say,
Yes, I'd like to add to what
Professor Matunga?
our Prof. CJ stated on ethics. When we talk about judicial ethics, there are different laws in place to regulate the conduct of judges or members of the bench at the international level and the national level as well. When you take Ghana, for instance, on issue of ethics, we have relevant constitutional provisions which discusses issues of ethics not only for the members of the judiciary, but for all public servants. Issues of conflict of interest and all of it is catered for in the Constitution. Then also we have other statutes that speaks to the same issues. The judiciary have specific statutes specific to the service. It all contains relevant provisions on the issue of ethics and how judges of both the lower courts and the superior bench are supposed to carry themselves independently, with integrity, with dignity, all of it are found. Then again, we have the code of conduct for members of the bench as well. When you take each of these sources of law, policy directions and all of it, it touches on all the things a judge needs to note in the conduct of their work to be seen as effectively dispensing justice freely and fairly. There are laws in place. But the difficulty lies probably in implementation. That's always, we have all the laws. But the issue of the disconnect between the theories and the practice has to do, in my view, with the issue of enforcement. There are many judicial officers who have fallen short of these very ideals in place to regulate their behavior on the bench and even out of the bench. Once you're a judge, you are supposed to what? Put up a high level of professionalism, of integrity at all times, whether in the courtroom or outside the courtroom. So where in the eyes of the public, you are smelling of cash, way beyond your means, you put the image of the judiciary in a state of what? Disrepute. It raised unnecessary eyebrows to the kind of work and that perception of corruption.
So maybe you tie
Yes.
in with the question about whether or not there are clear rules of exit, particularly for people who are seen to compromise themselves, getting corrupt.
Yes, there are units. There are units within the service that deals or handles issues of disciplinary matters. But not all the offenders find themselves being hauled before the disciplinary committee. Some are so powerful, no matter what they do, they will not go there. They never end up there. But for the few unlucky ones, they get themselves being invited to answer to some petitions. And where they are found culpable, they are shown the exit. It happens here. In the research, we came across, in fact, what happens here happens in Kenya, it happens everywhere. We are the same people in Africa. The problems confronting one finds expression in the other. Issues of corruption, it smells everywhere. We don't want to mention names.
Okay. Yes. Please bring the microphone. So these two hands were up before this one. So take the lady in brown, then the gentleman by her.
Thank you. Lady Justice, I just want a bit of your comment on the institutional reforms that you highlighted, because I'm just wondering what are the parameters when the institutional reforms are being recommended? How do we take care of these challenges that we are highlighting? Because many times it's not just in the judiciary. Africa takes institutional reforms but spins back to the same position. And in the case of the judiciary, you're really struggling between the constitution, the people, and politics. So what are the key parameters when it comes to dealing with those critical areas that would make a reform make sense?
Thank you. So, Prof, you get ready to answer that quickly. Yes. Yes, to him.
Yeah, mine is a point of caution in how we interpret judicial independence in the African context. We have seemed to rely very much on formal structures and including the laws and saying that the laws can promote judicial independence. But from what the Chief Justice Kenya was talking about, we noticed that there are informal ways, informal pressures that are put on the judiciary to make it less independent. And I believe if probably the Chief Justice can give various examples of informal influences that actually he has had in his office. And some of the best examples that some of us who are in the know can relate to is the fact that he wouldn't pick up a call even from the president, right? From the outset, the president would even want him to go to office of the president to have a meeting. But in the first instances, that pressure, by asking a simple question, now did you know the Chief Justice there is free, meant that all those influential people around the president ran away from calling the Chief Justice anyhowly, right? And that is the practice that was promoted throughout. And one can also talk about different other informal ways. And I'm raising this simply because we tend to ignore informal institutions that undermine independence of various institutions. Africa is a country run by informal networks, ethnic pressures, religious pressures, name it. And yet we tend to emphasize much more on how the law is made and how and those other things. We don't pay attention to nuances.
Thank you. So, Professor Mutenga, two from the lady and from him. Please hold on. I come for the next and last round, where I'll take at least 4 questions. Yes, Prof. Right. Please give the microphone back to her to repeat her questioning in a summary in respect of the parameters that she was seeking. Yes, you. Yes, please.
Oh, yeah. It could be very close to what he's saying, because we struggle to reform institutions, and I'm saying the ones you listed. What are the pillars? What informs why the demand for that institutional reforms? And in the reforming, what are the key indicators that you are taking into consideration? Is
Right.
it just anchoring it on the Constitution, or also considering other parameters?
Right. I think the second was just a suggestion. Yes, so please.
Yeah. In our case, we discussed blueprints, okay? About those particular issues. We had a judiciary transformation framework that focused on 4 pillars, and it was for 4 years, and it's something that wasn't done by lawyers, because we realized that lawyers, we always say we are learned, but we're very ignorant of other disciplines. So we did bring in economists and political scientists, and we drew that framework and focused, on those particular issues we thought were urgent, like backlog of cases, the issue of technology, which became very important in the judiciary, and how, as I said, how the institution has to deal with these pressures, encouraging as many associations as possible. But the legal framework was, legal framework is also very, very, very important, in the sense that in the case of Kenya, there is a call now for forensic audit of actually those declarations that are filed, but again, it's a collective thing that you have to put out there to the public and implement it, knowing that it will be resisted, and that the next Chief Justice will have to carry on, with the issues. Yeah.
All right. Next set of questions, 4 of them, be very straightforward, and we are done. That's the next and last. Yes, you.
Yes, thank you very much. So, to the 2 speakers, we currently have a revamped wave of citizen social movements. You have Occupy Ghana, you have this Kenya Gen Z movement. What opportunities and challenges does that present for the judiciary?
Okay. Next. Please, the lady 3 rows back.
Thank you very much. My question is to my lady who has undertaken the research. Is there any best practice which you identified on which we could follow in promoting the judicial independence? Also, I would like to know what exactly would be the role of the AJIF to promote judicial independence in Africa. Thank you.
Can you say that again, the last question?
What would be the role of AJIF in promoting the judicial independence in Africa?
Thank you. There are two hands up here on my left.
Thank you very much. So to the lady on the panel, I just want to ask this question. I think you mentioned something in your presentation. What do you foresee as a potential danger should there be, let's say, an election dispute, and then the CJ that was appointed by the incumbent government rule in favor of the opposition?
Okay.
What do you see as a potential danger
for our
democracy?
Thank you. The very last question. The gentleman in white in front here. Yes, thank you.
Thank you very much. I'm not sure whether mine is a question. Rather, we repeatedly speak about the independence of the judiciary, and I'd like to think independence comes with a level of responsibility and accountability. And I feel the judiciary has always, one way or the other, avoided the kind of scrutiny and accountability that the other arms of government often face. So my question, if it is a question, is really to hear your reflections, both of you, in terms of how you strengthen that as well, because I don't believe in simply strengthening the independence of the bench without actually talking about how the bench remains significantly accountable to the public, as we have seen in the case of the US with the Supreme Court justice who was exposed for what is less than accountable behavior.
Thank you very much. So, first, maybe Professor Motenga, you start the wave of movements, pressure movements we are seeing. What does it present to the judiciary?
I know the current Chief Justice, when this was happening, said that the courts will be kept open for people who want to make applications or habeas corpus, people who are being abducted, so that people can actually access court and make those demands. Then, what the applications that might be filed were also fast-tracked, whether it's public interest litigation, and I think that was a nice thing to do under the circumstances. Not also to mention that
so that was proactively asserting the independence of the judiciary.
Yes, and there was also collaboration with the Law Society of Kenya also that came out to defend those who are arrested pro bono and go to police stations because it's the whole demonstration was anchored on Article 37 of the Constitution. That's you can demonstrate peacefully and unarmed. And it's only the police who are obviously armed. So the Law Society has played a very, very, very important role there, where and the judiciary, the only thing the judiciary could do is to keep the courts open for any applications or any pleas and prayers that will be there. And I think even when judges speak, I mean, there's this notion that judges speak through judgments and whatnot. I think in the case of Kenya, you find when there's an opportunity, judges are involved in kind of civic education, talking about certain aspects of
Does
the
that not
constitution.
present the danger of what Kojo Pumpuni Asante mentioned earlier, suspicion of bias? Because even though you are being proactive, then suggest that inviting these people to come, you will set them free by habeas corpus applications
Yeah,
and all.
I don't think so. I don't think so. It's you're telling people, you know, what their rights are.
Right.
Okay.
Mm.
And we had those issues where people go to church and they are asked by the pastor, you know, to answer certain questions, and the judges would say, no, this I can't do this. Okay.
All right.
And we had to sit down and basically say there's no harm if in church, if you are being asked about the constitution and being held accountable, as Deus was saying, people might want to ask.
Okay,
you know,
what do you
those
see
questions.
to be the role of the AJIF in this process, promoting judicial independence?
That's what I flagged actually in my final comments. You know, whether they will, in a case like where there is movements, where they will obviously help.
Mm.
Yeah. But they have to basically deal with the issues of the challenges, you know, as well. Africa
Okay.
is a big country.
This question was directed
Continent.
to you. Political case there is an election petition and a chief justice who is appointed by the incumbent government rules in favor of the opposition, say a presidential election petition. Are there any dangers you see?
That would be wonderful if it would happen. And it has happened before in this country. It's not always the case that chief justices or heads of judiciary appointed by a certain government always become predictable. Sometimes it may happen that the election dispute would favor the certain government. Other times, it doesn't go in that direction, okay? So when it happens that for a certain government, their desired election result does not go their way, and it goes in favor of the opponent. As to whether the members of the bench would feel threatened, I don't think so.
I think he's asking on the basis of the fact that
Yes.
there's no history yet for us in Africa where the incumbent lost an election petition or an election petition brought against the incumbent was successful.
What there was in Kenya in 2017.
There
Okay.
are records to that effect.
Okay.
There are
And I
records.
think Malawi and some other.
It happens
I
often.
suppose he's Ghanaian, so he's looking at the Ghana situation.
Everything is possible, they would say.
Okay. The other question was about an accountable bench.
Yes. I heard the question. The impression our brother was created was that unlike the other organs of government, the judiciary is feared. It's not held accountable in any way. But I wish to disabuse your mind on that fact. The judiciary also goes through some form of a scrutiny, in particular by members of the public. If you watch mostly discussions that go on in the print media, from time to time, the judiciary is discussed. Their performance is thoroughly discussed. And sometimes when they go beyond their limit, it also falls into the realm of what we call the contempt of court. So we have media practitioners and concerned citizens who wish to ventilate their concerns concerning the workings of the judiciary they do so with a little bit of tact, unlike the other organs of government. We are all in this country when some media practitioners were hauled before the Supreme Court on the issue of contempt. That's the only difference. Most people wish to scrutinize more of the work of the judiciary, but for some of these laws in our books, there's that fear and the hesitance to come out boldly. But again, apart from the use of the media, which holds the judiciary accountable, there are instances where the judiciary as an institution was hauled before the Public Accounts Committee, for instance in Ghana, to render accounts in respect of certain resources that was entrusted to the service. And at the end of the day, the matters were determined at that level. And so the judiciary equally faces some form of scrutiny in similarity to the other arms of government. And I believe same applies in the other African countries, including Kenya.
Right.
Yes.
Ladies and gentlemen, thank you very much for your questions. I would want to call that we hear your final comments in a minute each, but Professor Motanga, if you can, in making your final comments, reflect on the issue of gender equity that you mentioned. How central is that to independence of the judiciary?
Yeah, I think it's central because the issue that I flagged was also the constitutional provision that were implicated in that equity and equality, and we discovered that although there were many women, about almost 50% in the judiciary, but they are not in leadership. They were subordinate and all that, and so we had to, the Court of Appeal didn't have a woman. And so there was that commitment, you know, to getting women in positions of leadership. And that has worked, you know, very well because in Kenya now the Chief Justice is a woman, the Deputy Chief Justice is a woman, the Chief Registrar is a woman, and some presiding judges who are also women. But that was the implementation of a policy that is anchored on the Constitution.
Thank you. Your final comments, if you could also reflect on what you have found and what would be the most effective framework in securing the independence of the judiciary.
Of notable mention will be the regional collaborations, efforts carried on by the East African Court of Justice, the South African Development Community Tribunal, where they're able to settle disputes across borders as an independent institution, where they have very transparent appointment systems in place, which is really working. And so I would recommend these examples for us to look at their operations and replicate similar that will work in our various regions to promote judicial independence.
Thank you very much. Please, a round of applause for our speakers. Professor Wele Mutenga and Mavis Kweno, thank you all so very much. Please, as they take their seats, we will now do a very important thing to climax what we are doing right here. We will have the associate program associate of the Africa Judicial Independence Program, who is the CEO's executive assistant at Afrobarometer and serves as the program associate for the Africa Judicial Independent Fund, to help us with unveiling of the logo. Linda Teresa Abbey, please put your hands together for her as she comes up. Ayo Obi will also join us in this.
Thank you, Samson. Hi, everyone. So I'm here to basically explain to you the logo that we have, the concept behind the logo, and also explain the symbolic element that encompasses the logo that we have. Yeah. All right, so somebody would ask, why are we having a logo? So for the AJIF team, we think that a logo is a virtual representative of the fund. The logo helps with brand identification as well as differentiates the fund from any other fund. So the concept behind the logo. Our logo is entitled Guardians of Justice and is a visual representative of our values and our mission as the Africa Judicial Independence Fund. The logo design as well captures the mission, the values, as well as the mission of the fund. It features the scales of justice, the two pillars of support. We have the shield, which is protective of the design, as well as an African continent motif. Now, we will delve into the symbolic representatives of the elements in the logo. First of all, we will talk about the scales of justice. Universally, as known, the scale of justice represents fairness, balance, and impartiality. It represents the judiciary's role in maintaining justice and the rule of law. So as you see in the graphic there, we have the design showing the AJIF scale of justice. So normally you wouldn't see it like this, but this is something that's specially made for AJIF. So we move to the next symbolism. That's the strong pillars of support. So when you see the design, we have two blue pillars supporting the scale of justice. Why do you have these two pillars, the ones in blue? It's incorporated into the scales of justice just to give it a reinforcement that the independence and resilience of African judiciary is a concern to the fund. We move on to the shield of protection. So above the scales of justice and the two pillars, we have a shield of protection, which signifies AJIF's objective to safeguard judicial independence. It represents our commitment as AJIF team to protecting judicial officers from threats, external pressures, as well as internal pressures. The African continent motif. So the image you see here shows a map that signifies the Africanism that the fund place importance on. The logo incorporates an abstract representation of the African continent. It emphasizes the regional focus of AJIF efforts. So when you come to Africa, it's not only like 2 countries here. Our madam mentioned we are working in 11, actually 10 countries, but the landscape scan report covered Ghana as well to make it 11. So we are actually talking about the whole of Africa. For now, we are focusing on 10 African countries, but as we move on, we extend to other countries. All right, so our logo has a number of colors. We have deep blue, we have rich green, and we have warm gold. I must say that each of the colors symbolizes something significant. So the multiple colors that we have here is used to represent the diversity of Africa. When you check the logo, the colors are blended in a way that signifies unity and cooperation, as well as, collaboration, which is needed to preserve judicial independence on the continent. The deep blue color symbolizes trust, stability, and strength. We have rich green representing growth, renewal, and the pursuit of justice. We have warm gold as well, seen somewhere on the logo. It signifies hope, prosperity, and positive change. Yeah. So in conclusion, we are saying that the Guardians of Justice logo embodies AJIF's vision to safeguard the rule of law and judicial independence on the continent. It is designed to be instantly recognizable and also to make stakeholders understand and want to be part of, and also for those who share in our passion for preserving judicial independence. The scales of justice, the 2 steady pillars of support, and the shield collectively symbolizes AJIF's role as a steadfast contributor to the independent delivery of justice across the continent. The African continent motive emphasizes our regional focus, and the colors that we see in the logo underscores the fund's values and aspirations. Thank you for your attention. So we have Madam Ayo. She would come and she would unveil the logo. I know most of you have seen the logo around, but this is the official logo unveil. Thank you.
Surprise, surprise. I think Linda has said it all, actually, and I would only add that the logo was one of the first official decisions that we took as the Advisory Council. So I hope that you are suitably impressed by the results of our deliberations, and that when you see this logo, you will know that the independence of the judiciary is, well, we said preserved, but sometimes it might also be being established. But in any event, the end result will be a more independent judiciary that really lives up to what we expect of it. So, as I said, surprise, surprise, because you've seen it before. But here is our logo.
Thank you, Ayo. Now let's have Said Salahuddin back to tell us the next steps. We don't end in this room. where are we going with the Africa Judicial Independence Fund?
Thank you so much, Samson, and good afternoon once again. It's a privilege to be back to speak briefly on the next steps regarding the activities that AJIF will be embarking on. We have heard from two distinguished speakers, one being a former Chief Justice of the Republic of Kenya, the other being a former judge of a lower court in Ghana, and at the same time a consultant to the AJIF landscape scan. As I said at my welcome address, our purpose here is not just about presentations and discussions. Our purpose goes beyond that. We want to build a network of champions for judicial independence in Africa. We want to be able to provide support and related activities to institutions and individuals working to uphold the principles of fairness, firmness, and impartiality in the administration of justice. So how are you going to do this? In close collaboration with Afrobarometer leadership and the advisory board of the Africa Judicial Independence Fund, the fund management team will be rolling out a 5-year operational plan. Our operational plan will be segmented into year 1 to year 2. Year 1 to year 2, which embodies launching the fund as you have observed. So we can say we have achieved that with your support. Apart from launching the fund, we will be fostering partnerships. We can't do it alone. AJIF is not an implementer. AJIF will only support implementers. So we will foster partnerships and collaborations with CSOs, individuals, bar associations, and other well-meaning bodies that truly are interested in supporting judicial independence. Once we build those partnerships, we will provide financial and logistical support by way of subgranting to these interested parties. In year 3, we will have learned from some of the subgrants that we have done in year 1 and 2. Then we will, based on the pilot, we will scale up the success stories where we get it wrong, which we do not hope to, but as humane as we are, if we get it wrong, we would have learned from the experiences in year 1 and 2 and then correct that in year 3. In year 3 and 4. In year 5, we will then sustainable scale up the success stories. But even apart from the 5 years, we seek to sustain the fund beyond that. That will mean that we can only do all of this if the fund itself is well resourced. After all, you cannot give what you don't have. In that regard, we have also been working on a fundraising strategy. We have had some support thanks to the help of Open Society Foundation for the support. But like Oliver Twist, we ask for more. And for that matter, we will be coming to all of you, individuals, corporate bodies, civil societies, and any other person that has any support to give to the fund so that the fund will in turn give out to the other implementing bodies. We are also aware that we are rolling out AJIF at a time that many citizens on the continent have become disillusioned, disgruntled, and disappointed. And for that matter, when we even mention AJIF, some people will think that this is one of those things that they are coming up with again. And it will mean that it will be an uphill task for us to get the buy-in and support that we need. We are well aware of that. We will strategically position ourselves to revamp interest and support in the citizens to the realization that all is not lost. We can do it together. Together, we can make that positive change that we desire. Together, we can ensure that the judiciary in Africa remains a pillar of strength and integrity. Thank you.
Thank you, Said. We will now invite the CEO of Afrobarometer to close us. Joseph Asunka is the CEO of Afrobarometer. Previously, he was a programs officer at the Hewlett Foundation and a political science lecturer at the University of California, Los Angeles. His research focuses on distributive politics, elections, and migration, with publications in several notable journals. Please, let's welcome Joseph Asunka. And please, when you are done, we would like you to invite all members of the advisory board to return to the frontier together with what IO was doing. We need all of them back here so that we can do it and do it well. Thank you.
All right, thank you so much, Samson. And I want to start by saying a big thank you to Samson Ladi Ayeneni. Samson is one of the top journalists in Africa, I should say, but of course in Ghana, he is well known, a strong lawyer who is well known for his work all around the country. So really thank you so much for agreeing to facilitate this. I want to close just with a few remarks, but before I close, I know we have been partnering with the Open Society Foundations on this project, and it is partly a brainchild of one of the representatives from the Open Society Foundation. Of course, as you can see on a display this, one of our board members said she's happy not to see OSF logo here, and I said, yes, they won't even allow us to put a logo here because this is an independent fund. It shouldn't be associated with a particular funder. All right, so I want to call on Sharon to just say one or two words about why they are committed to this effort, and I'll conclude.
Thank you so much, Joe. And I know you had to force me to even give these remarks, again emphasizing independence of this fund. But just to say that I wish my colleague and sister Afia Asantewa Asariche was here, because it was under her leadership that this was conceived. But also just to congratulate you upon the 25-year anniversary. Some of us enjoyed the party quite a bit, as you saw. And it was because this is a real demonstration of resilience, especially in the face of the kind of threats that we have seen civil society and open societies overall facing. So to see an African institution get to this level is extremely inspiring, and I hope some of those lessons will be shared across the continent. Afrobarometer has been a long-term partner of OSF, so we thank the team for agreeing to collaborate with us on this Africa Judicial Independence Fund. It's an initiative which we believe will go a long way in advancing democratic values on the continent. And as you noted, I think Said said it, citizens are very disillusioned, but we can't give up necessarily. This is one of the steps we're taking to say our institutions are important and will not surrender. We'll die trying, at least. And I'm attending this event fresh from having had the privilege and opportunity to participate in a high-level Pan-African engagement, a mission organized by another of our partners, the African Judges and Jurists Forum. I don't know if Justice is in the room, but there were several issues that came out in the course of the mission that they organized. So one was the important role of progressive justice reforms, because they present opportunities for cross-regional exchanges and lessons on best practices from other jurisdictions. So that is what we would hope the fund would equally do. Then the continued disproportionate representation of women in the judiciary, which again necessitates that we champion campaigns for their appointment as well as their entry into the legal profession. The third bit was around overall consensus on the transformative role of judiciaries in strengthening democracies, but this will require us to focus on fighting for strong and accountable judicial systems which prioritize the independence of the judiciary, which prioritize protection and support of judges who rise up to defend the rule of law, at times at their personal expense, and of course funding for the judiciary. Then there is a commitment to building justice systems that represent our African values, questions around consensus, equity, solidarity, Ubuntu as we have had. A recognition as well of the continued disconnect between citizens and the justice systems and institutions because of lack of access, because of the complexity of the legal processes. So how do we change that? Not forgetting, and it's been mentioned here as well, the complementary role of our regional courts, which are also a source, are an option for citizens when it comes to seeking accountability as well as redress. It is something that we should not forget. These are our African institutions which we need to nurture. So, as I've said, judiciaries continue to serve as one of the main guardrails against rising authoritarianism. Despite their weaknesses, they are often our go-to solution. In the face, when everything else fails, we usually turn to them, despite criticizing them over time, that they're useless. But when everything falls, the first thing we all ask ourselves, where are the judges? Why can't we go to court? So that is something that we have to realize. They've played a critical role in the face of upcoming movements, the rights defense movements and moments that we have. So the launch is timely towards strengthening this democracy project that is important to the Open Society Foundations. I'll end by just saluting and thanking the AGIF advisory board members who have agreed to graciously give their time. Thank you so much. As well as the management team. I was so amazed when the logo was being launched. I said, wow, this is fascinating. So it's really good to see the thought process that has gone into this, the commitment of the Afrobarometer team, and all of us here, for the most part, sitting through conversations around institutions that have frustrated you is tough. But a lot of you are still seated here, which is a demonstration of your commitment to build, protect, and ensure stronger African judiciaries that are committed to protecting the rights of all of us. Thank you very much.
All right, so when I called Sharon to come and speak, I just knew that she was going to give the closing remarks. So I couldn't have given a better closing remarks than this. And so I now want to invite the board members, advisory board of the Africa Judicial Independence Fund to come up. I think our communications team want to get a photo opportunity together with a logo. And then after that, we'll invite the rest of our board members to join them for a photo. So Professor Mutunga, Kajal, Professor Luada, and Nayo, thank you so much. And let's give them a round of applause. Oh yes, so Linda and Said, yes, the project team. And these are the whole project is being carried by these two strong shoulders, I hope. All right. All right, there you go. All right, so I'll call on the rest of the Afrobarometer board members to join them for one more photo, and we'll go for lunch. All right. Now, as a result of some spiritual forces, these things were supposed to pop up and give us some celebratory event, and there are some spiritual forces that have not allowed them to happen. So, but in your mind, think of it that we had some explosion here. Okay, so thank you all so much. Thank you to the board members, both Afrobarometer and the advisory board, and thanks to the AGIF team. We are grateful to you for sitting through, and I'll send back to Samson for conclusion.
Thank you very much, Doc. Please, everyone, lunch is served, so you know the restaurant. That's where you go, and thank you all very much. Please, your commitment should not end here, because as we know, we need to continue to ensure that our judiciaries are independent and they will give us a just society. Once again, thank you very much for availing yourself. And as you see, there's a photo booth in front there. So make sure you catch a photograph before you go. Memorable for yourself. If you came as a group, also do take a picture at the photo booth. Thank you.